Good morning. Today, this is our second video from Citizens' Rights for going live streaming. Today, we will discuss one provision of Order 9, Rule 9 of the Code of Civil Procedure. Now, it is our endeavors to discuss one sections every day so that we can give a lessons to the law students and the general people, general public about the law. Our intention is to create awareness amongst the citizens. So we have decided to discuss on a particular sections each every day, if possible. As we are a professional, we used to attend the court regularly, so it is not possible for us to maintain a time. Anyway, today we have decided to discuss on Order 9, Rule 9. What is that? Order 9, Rule 9. Sometimes it is happens that plaintiff has filed a suit. Now, the date when the court has directed to be present for hearing, plaintiff could not appear. Maybe some other reasons. And if the learned advocates whom the plaintiff has engaged has also failed to attend, then court has nothing to do but to pass an order under the provision of Order 9, Rule 8 of the Code of Civil Procedure. Then what is Order 9, Rule 8? That is procedure where defendant only appears. Sometimes, as I have told, that plaintiff could not attend, neither his learned advocate was present. Then what is the left option with the court? This is the only option, that where defendant appears and the plaintiff does not appear when the suit is called on for hearing, the court shall make an order that the suit be dismissed unless the defendant admits the claim or part thereof, in which case the court shall pass a decree against the defendant upon such admission, and where part only of the claim has been admitted, shall dismiss the suit so far as it relates to the remainder. If we say in simple words, that when defendant appears and plaintiff failed to appear, then only court has only option to dismiss the suit. But court has also another option. If the defendant admits the claim that was mentioned in the plaint, and court can pass a decree against the defendant on the part where the part has been admitted, and then the suit can be dismissed because the suit has filed by the plaintiff. Defendant has nothing to do. Defendant can ask for any relief. If he asks for any relief, then he has to file a counter claim. But in case the plaintiff is not present, then the court has nothing without to pass an order of dismissal of the suit. Now, in that case, what is the remedy to the plaintiff? This is our topics for discussion. What is the remedy for the plaintiff? Somebody would say that let the goes, the suit has the dismissed. Let us not pursue to that old case. Let us file a fresh suit. But no, court has no jurisdiction. Neither the procedure has says that the plaintiff can file another fresh suit on the self same cause of action. So, what is the remedy? The Act says, Order 9, Rule 9 of the Code of Civil Procedure says that where a suit is wholly or partly dismissed under Rule 8, the plaintiff shall be precluded from bringing a fresh suit in respect of the same cause of action. The section has specifically stated that plaintiff is precluded from bringing a fresh suit in respect of the same cause of action. But what he can do? He may apply for an order to set the dismissal aside, and if it satisfies the court that there was sufficient cause for his non-appearance when the suit was called on for hearing, the court shall make an order setting aside this dismissal upon such terms as to cost of otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. Then court can pass an order setting aside the dismissal of the suit and fix a date for hearing. Now court has also has an option to see that in the event the suit is restored, whether the defendants will suffer any loss or injury or damage. If the defendant does not suffer any loss or damage, then court can restore the suit, provided court has a power to pass an order on to pay cost for the uh, against the plaintiff, but the court has power to restore the same. Now this is Order 9, Rule 9 as specifics. There is another provision: no order shall be made under this rule unless notice of the application has been served on the opposite party. The court can has to power an order to hear both the parties. That means the defendant against whom the suit was filed, he has to serve a notice so that he can present his case, why he is opposing to restoration of the suit, and upon hearing both the parties, court can restore it, dismissal the earlier order for this of the dismissal of the suit and restore in its original file. Today we will close this video. Thank you very much for viewing us. I will request you to subscribe and share my videos to law students, senior citizens, those who are interested to know about the present scenario of the law. I will request you to share it and subscribe it our channel. Thank you.